I'm Micah Josh in New York. Let's get right to breaking news. In Washington, the Senate unanimously approving a bill tonight to release the Epstein files, now sending it to President Trump's desk. The president saying earlier he plans to sign it. The Senate wasting no time approving the bill just hours after the House voted 427-1, ordering the Justice Department to release all its records on convicted sex offender Jeffrey Epstein. No one objected in the Senate. Survivors of Epstein's abuse clapping and hugging as the vote passed the House earlier. ABC News investigative reporter Olivia Rubin is with me now with the latest. Olivia, this unanimous action by the Senate tonight means that there'll be no amendments to this bill, but we just saw House Leader Mike Johnson essentially say that he wanted some changes to this bill. So what are we looking at right now?
He wanted it, and clearly he's not going to get it based on what you just said about the Senate. And it does seem like to be a rebuke from the Senate to Speaker of the House, Mike Johnson there. As you said, he had said that this is what he wanted. And I think it's just important to point out how quick this happened. It's very rare that you see something move so quickly like this, right through the House, right through the Senate, especially in this day and age, to have such bipartisan support on something, just one member not voting along with it. That's remarkable here. So I think now really the big question goes to what does President Trump do by how quickly this is moving? It wouldn't be shocking if potentially this does make it to the president's desk tonight. And remember, he has indicated he will sign it. But the question is, how quickly does it get to him? Does he stick by that? And then from there, how quickly does the Justice Department act? Because remember, this is a bill that compels DOJ to release the documents that it has. Right. So then it's on them. Remember, we're following the ball here. House, Senate, Trump's desk, DOJ, which seems to be the final line there.
Right. Now, we just saw the Senate again pass this bill. Has President Trump come out and said anything since the Senate made that move?
Well, he posted a few minutes ago on social media, just to kind of walk you through it. He said essentially that he didn't care when the Senate passes it. By the time he posted that, it seemed like they already may have. So it was tight timing there. But saying really the same message that he has stuck to in recent days, which is that he, quote, doesn't really care what happens with the files. What he really doesn't want is for Republicans to, as he puts it, take their eye off the ball of some of their key agenda items there, right? And then he went on in this post to list out a number of things he views as his administration's successes, but it also sort of fits with this shift a bit in messaging that we've seen since from the White House since the elections just a few weeks ago, where voters really spoke on affordability, the economy. The president seems to be trying to stay focused on that messaging rather than talking about the Epstein files, which he has indicated time and time again he just does not want to talk about, Ike.
All right, Olivia Rubin, thank you for that update. All right, for more, I want to bring in Nima Ramini. He's a former federal prosecutor and now the president of West Coast Trial Lawyers. Nima, thank you for joining me. What legal privileges does the Justice Department have in choosing what to redact?
Ike, that's the question here. And it's not just redaction. And Olivia talked about the political process, but really it's the legal one that matters here. Let's not forget, the Justice Department, Attorney General Pam Bondi, with a stroke of her pen, could have released the full Epstein files and waived the privileges that apply here. We're talking about the law enforcement privilege, the deliberative process privilege, and maybe the executive privilege. Now, if they choose to follow the law and disclose the entirety of the Epstein files, there's really only two categories of information that can't be produced. The first is grand jury materials. That has to remain sealed and secret unless a federal judge orders them produced. And the second would be identifying information for victims of sex abuse. That has to be redacted. But other than that, if the DOJ chooses to comply with this law, they have to produce everything. Now, of course, the Department of Justice can choose to assert these privileges, saying that they're still investigating individuals in the Southern District of New York, U.S. Attorney Clayton there, and therefore they're not going to comply, in which case we're setting up a dispute between Article 1, the legislature, Article 2, the executive branch, and an Article 3 judge will have to sort through those privileges. So it'll be interesting to see what the DOJ does, like Olivia says, but let's not forget, this act really wasn't necessary. They could have released these files on their own and waived the applicable privileges.
Right. Now, I want to make sure I get your name right. Nima Ramani. I messed that up before. All right. Now, President Trump, he's also asking the Justice Department to investigate several high-profile Democrats alleging they had a connection to Epstein. So how could that action impact releasing information?
It could. So if there's an ongoing investigation, we've all heard that. That's where that law enforcement privilege applies, right? So whether it's the media, whether it's Congress, a civil plaintiff, they can't subpoena the Department of Justice to produce its investigative files. But even if an investigation is closed, the deliberative process privilege doesn't require the DOJ to produce these files. That's typically how it works. Now, obviously, we know that the DOJ in July issued a memo saying there's no legal basis to go after any third parties or prosecute them or investigate them as a result of the Epstein abuse. So if they were to investigate the Bill Clintons, Larry Summers, Reid Hoffmans of the world, these are individuals that the president has identified as potentially being associated with Epstein. Well, that would be a 180 for the DOJ as well. Let's not forget Bondi and high-level folks there said there is no Epstein list and there is no basis to go after other individuals. So if Clayton and the assistant U.S. attorneys in the Southern District of New York do, that would be an about face for the DOJ.
Now, is there any legal rationale for the Justice Department to choose to not release these files?
I don't think so, especially when Trump ran on this issue. Bondi and Patel, before they were appointed to those positions, said they would release the files. As of earlier this year in February, we thought we would have the complete Epstein files. So I don't understand why the administration is sitting on this. But I also want to raise one very important point. If we're talking about the law, even if the full Epstein files are released and we see the FBI interviews, all the emails, the videos, unless there's a victim who's ready, willing, and able to testify against someone who's alive, obviously can't prosecute a dead person, there's not going to be a criminal prosecution here because under the rules of evidence, what's been produced so far is hearsay. And under the confrontation clause of the Constitution, someone who's accused, a criminal defendant, has the right to cross-examine his accuser. So the emails, they can't be introduced as evidence. Virginia Giuffre's memoir, similarly, can't be introduced as evidence. Those FBI interview notes, the same applies. So unless there's a victim that comes forward, Ike, we're probably not going to see the prosecutions in criminal justice that many people are asking for.
Interesting points. Nima Rahmani, thank you very much for your analysis.